Okay, so the next topic is the Sablayan Penal Farm. So nearer to Manila than other penal colonies, the Sablayan Penal Colony is located in Occidental Mindoro and relatively new. Established on September 26, 1954 by virtue of Presidential Proclamation number 72, the penal colony has a total land area of approximately 16,190 hectares. Prison records show that the first colonies and employees arrived in Sablayan in January 15, 1955. Since then, the several buildings have been constructed, including the colonies' dormitories, employees' quarters, guardhouse, schoolhouse, chapel, recreation hall, and post exchange. So this is the Sablayan Penal Farm, which was established on September 26, 1954 by the virtue of Presidential Proclamation number 72. So the three sub-colonies were later organized. One is a reservation, which is they remains part of a protected rainforest. Another is a coastal area. The third was used by the national government as a relocation site for refugees from the eruption of Mount Pinatubo in 1991. So the Sablayan prison is a facility where prisoners from the NBP are brought for decongestion purposes. It follows the same colony standards as the penal farms. So this is how the Sablayan Penal Farm looks like. On the other part, or it has three sub colonies. The first one is the rainforest, and the second one is the coastal area, and the third one is the relocation for refugees. Unlike any other or the usual penal colony, the prisoners here are almost enjoying their freedom. Instead of being locked down inside concrete structures with metal bars, they roam around the area without so much restriction. They also made to till the land area so as to have their own supply of at least basic foods requirements for during their stay. So this is what you have seen in the picture I have shown, that they have their somehow own supply of at least basic food requirements, and then the life of the prisoners here in this Sablayan Penal Farm is not so strict that they can roam around without so much restriction. Prisoners are also allowed to build their nipa huts, and since it is a mix of different religion, churches and worship houses are constructed to cater various religions of the prisoners. So this is how the penal farm of this Sablayan prison looks like. Some inmates were also allowed to have their wife or husband to live with them inside the colony. This is evident by some playground around the area. The penal provide also an access to road vehicles from Sablayan going to Abra de Ilog Port. Next is the Leyte Regional Prison. The Leyte Regional Prison, situated in the Buyug, Southern Leyte, was established a year after the declaration of martial law in 1972 by virtue of Presidential Decree number 28. While its plantilla and institutional plan were almost ideal, lack of funds made the prison unavailable or unable to realize its full potential, and its facilities are open below par compared with those of other established penal farms. The LRP has an inmate capacity of 500. It follows the same agricultural format as the main correctional program in addition to some rehabilitation activities. The prison admits convicted offenders from Region 6 and from the National Penitentiary in Muntinlupa. It also composed of two communities, the enclosed community and the open community. So prisoners who were in the enclosed community are those belong to the medium and maximum security, while prisoners who are open community belongs to the minimum security. As of March 19, 1997, there are about 980 prisoners housed in this regional prison, with 204 at the maximum security and 550 at the medium security and 226 at the minimum security prison. So the prison admits convicted of offenders from the Region 6 and from the National Penitentiary in Muntinlupa. So next is this provincial jail system. So the provincial jail system was first established in 1910 under the American regime, supervised and controlled by the provincial government and headed by the provincial jail warden. So this is the purpose of having provincial jail systems. So the vision of provincial jail systems was an institute managed by God-centered professionals and trained personnel to serve as the provincial catalyst for rehabilitation, restoration that leads to reformation of the social, physical, and spiritual aspects of persons being detained to develop a law-abiding citizen for eventual reintegration into the mainstream of society. So, this, in their vision, or the vision of the provincial jail system, aims to reform or have the reformation of social, spiritual, and physical aspects of person being detained to develop a law-abiding citizen, and to enable them to re-enter the society as law-abiding citizens and has rehabilitated. So the mission, the office of the provincial warden shall promote safe and total detainment and rehabilitation, restoration of detainees under its custody. So their mission was to provide safe and total detainment for convicts. This is good rehabilitation or restoration under their custody. So their goals and objectives: the Office of the Provincial Warden is committed to carry out effective implementation of all programs, projects, and activities relating to jail detainment and rehabilitation of prisoners being sentenced, detained, or held by trial by the Court of Justice. Develop and attend to the welfare of detainees in the provincial jail by providing subsistence, and other welfare benefits, and through provision of jail decongestion programs. They provide protection services and prepare the inmates socially, physically, mentally, and spiritually to become productive citizens for their eventual reintegration into the mainstream of the society, pardon upon release. So the functions was to safekeep the prisoners convicted by courts 3 years and 1 day and above the served sentence in prison. So second is to prevent prisoners from committing crimes. Of course, they are being rehabilitated. 3. Provide inmates basic needs. This is part of the basic rights of the prisoners while under the custody of the Bureau of Corrections, that they should be provided with their basic needs. 4 is to ensure rehabilitation programs are made available to the inmates for their physical, intellectual, and spiritual development. 5 is to develop livelihood programs to assist inmates earn a living and develop their skills while in prison. So that's the purpose of having penal farms from different prisons or from the 7 penal agencies of the Philippines. So next is the legal basis. The Bureau of Prisons was established on November 1, 1905 under the Department of Instruction through Reorganization Act 1407 of the Philippine Commission until it was transferred to the Department of Justice. The prison law incorporated in Chapter 45 of the Revised Administrative Code of 1917. Section 26 of the Administrative Code of 1987 issued November 23, 1989 under Proclamation number 495 of the President of the Philippines, changed the name of Bureau of Prisons to Bureau of Corrections. So before it was named Bureau of Prisons and now it was named Bureau of Corrections. And the last topic was the Public Attorney's Office, or the PAO. So the Public Attorney's Office is an attached agency of the Department of Justice which provides indigent litigants free legal assistance. So, mandate to provide indigent sectors access to counsel at time of need. Implement the constitutional guarantee of free access to courts, due process, and able protection of the law. So, PAO Vision. By 2023, the Public Attorney's Office as the principal law office of the government shall be composed of highly motivated, effective, and empowered public servants consistently responsive to the ever-growing legal needs of the indigents and other qualified persons, utilizing modern facilities, information technology systems, and tools needed for efficient delivery of free legal aid services to promote access to justice, trust, or truth and peace. And the PAO mission is the Public Attorney's Office exists to provide the indigent litigants, the oppressed, marginalized, and underprivileged member of the society free access to courts, judicial, and quasi-judicial agencies by rendering legal services, counseling, and assistance in consonance with the constitutional mandate. Free access to courts shall not be denied by any person by reason of poverty, in order to ensure the rule of law, truth, and social justice as components of their country's sustainable development. So, PAO objectives and trust. So, to provide the indigent sector access to counsel at a time of need, to implement the constitutional guarantee of free access to courts, due process, and equal protection of laws. PAO's Enabling Law Republic Act No. 9406, PAO Law, an act reorganizing and strengthening the Public Attorney's Office, amending for the purpose pertinent provision of Executive Order 292, otherwise known as the Administrative Code of 1987 as amended, granting special allowance to PAO officials and lawyers and providing funds thereof. So, the PAO's Enabling Law Republic Act No. 9406, or the PAO Law, an act reorganizing and strengthening the Public Attorney's Office, PAO, amending for the purpose pertinent provisions of Executive Order No. 292, otherwise known as the Administrative Code of 1987 as amended, granting special allowance to PAO officials and lawyers and providing funds thereof, is implementing rules and regulations was signed on July 14, 2007. So the highlights of PAO Law was, the first is Chief Public Attorney, Deputy Chief Public Attorneys, and Regional Public Attorneys shall not be removed or suspended by except for cause provided by law. The clients of the PAO are exempted from payment of docket and other fees incidental to instituting an action in court and other quasi-judicial bodies. The PAO is exempted from payment of charges on postage stamps and mail matters. Public attorney's position at a ratio of 1 public attorney to an organized court sala. So, PAO lawyers have general authority to administer oaths in connection with the performance of duty. No need to apply before the courts for authority as notary public. And lastly is the Chief Public Attorney, the Deputy Chief Public Attorneys, the Regional Public Attorneys, the Provincial, City, and Municipal District Public Attorneys, other PAO lawyers, and officials who have direct supervision over PAO lawyers shall be granted special allowances not exceeding 100% of the basic salary of PAO officials and lawyers. So that would be all for my topic. Thank you for listening and thank you for watching. Bye!